the Texas Supreme Court is finally live. We can actually watch what we planned on watching. So let me get our stream connected and we can go ahead and start watching these Texas Supreme Court from today, which is what our show was from this morning. It has actually became live. Here we go. So, here we go. Full credit is going to go to the Texas Supreme Court. Here we go. Okay. And you got to spell it right, dumbass. There we go. Let's fix that. All right. Here we go. Yeah, after all morning, finally, it comes live. Yeah. Mm-hmm. Enter. Okay. There we go. Here we go. We are on Texas Supreme Court. Oh, thanks. Don't worry about that asshole thingy. There we go. All right. We are ready. It is ready. Let's turn it up. Let's go listen. This is what we planned on doing all morning. Here. Oh. It's not very loud, is it? Ooh, they've got poor. Let's see if we can fix it over here. It's really poor hearing. You can't hear it very loud. Audio.
Texas Supreme Court will hear arguments in two cases this morning. The first is 230676, Cactus Water Services against COG Operating from Reeves County and the 8th Court of Appeals. The second case is 2306.
Yeah, they're not very loud. There's something wrong with their feed. It's not very loud.
From Brazos County and the 10th Court of Appeals. In the first case, Justice Young is not sitting. Justice Boyd indicated.
Wow, that's pretty bad.
To participate in the case. The court has allotted 20 minutes for each side in each of these cases. We'll take a short break between the arguments, which can be viewed online and will be available on the court's website later today. Ready for argument in 230676, Cactus Water Services versus COG Operating.
So we can fix the sound. It's pretty low.
Ms. Livingston will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
Damn. That's so bad. Yeah. Let me see if I can. I can fix it over here. I'm going to go out and come back in and try it again because their feed is so poor, the sound. And I don't know if that's why they were running late today because they were having issues, but it's so you can barely hear it. So we're going to go try to go out of it and then come back in it. Okay, guys, let me unshare it so we can do that again. Here we go. So we're going to go back out and try to pick it up and see if we can't hear it better. It's ridiculous. It is ridiculous. Okay, hang on. One moment. Hmm.
Dallas County in the Fifth Court of Appeals. Number 24-1033, Faskin.
A little better, but not much. Just not much better.
In the Fourth Court of Appeals. And finally, case number 24-1070, River Creek Development Corporation versus Preston Hollow Capital from Williamson County and the Third Court of Appeals. The court is allotted 20 minutes to each side in each of the cases. We'll take a short break between the arguments, which are usually you can view them online. I'm told there are technical difficulties this morning, but we'll work on those and try and get the arguments up. And in any event, they'll be available online later today.
Well, I'm glad they actually talked about the difficulties.
Now, in case number 240924, NV Transportation versus GDS Transport.
May it please the court, Mr. Omenhouse, petitioner. Petitioners will reserve 5 minutes for rebuttal.
Thank you. Good morning. I represent NV Transportation, Inc. I wanted to start off by returning to fundamentals in this case. This is an appeal from an order granting a Rule 91A motion dismissing a claim for damages for fraud. And on the grounds that it has no basis in law, and you determine whether a claim has no basis in law under Rule 91A by looking at the allegations of the petition, fact allegations. Under Rule 91A, look at the allegations and the reasonable inferences therefrom to see if those allegations do not entitle the claimant to relief, in this case, damages for fraud. And I say that because it seems like the main point of contention in the briefing before this court is under this statute that we claim gives us this limitation of liability. Were we performing a function of DART, the Dallas Area Rapid Transit Authority?
And sort of to get to fundamentals,
Sure.
Can we determine whether you're performing a function of DART if the master agreement is not part of the Rule 91A record?
Yes, you can.
And how, by looking at the allegations, or?
That's right.
Okay, and from there we can confirm that DART delegated not only its authority to provide transport, but also its contracting authority?
Correct. Yes, I mean, all of that is actually alleged in the allegations of the petition, as I understand them, even without those documents in their entirety.
Because I saw the subcontracting agreement, but I didn't see the agreement between you and your client and DART.
That's correct. Yes, I mean,
that seems to be a little bit of a hole.
well, I don't think so. I mean, if the petition comes out and it says, and if you look at Section 4 of the petition, okay, paragraphs 1 through 5, it explains what DART's function is, right? And then it goes on and shows, and all the allegations after that, that we're performing that function. And so, so much of the provisions of this master agreement would really be irrelevant to that. It would be a lot of details.
How do we know that if we don't have the agreement?
Well, how do we know that they're irrelevant?
Mm-hmm.
I think you know that from the allegations of the petition. Right? Because do the allegations of this petition actually say, oh, there's some irrelevant stuff out there? Right? I mean, they say DART's function is public transportation. DART's function is this micro-transit, paratransit service. And then they say, and DART subcontracted this out to MV Transportation. They say, MV Transportation, you plan this. And go get subcontractors. And the petition says that's what MV Transportation did. What else would you need? It says this is DART's function. MV transportation is performing DART's function. And that goes to the issue of DART's function, right? I was returning to that because that seemed to be the main point of contention in the briefing. And
Because surely it's not DART's function to commit fraud.
that's correct. And that's why you look at the Rule 91A standard. You look at the fact allegations, not the legal theory of liability that the plaintiff says those fact allegations might fit.
So we're assuming that there was fraud.
Oh, yes. Oh, yes. I mean, that's what I do.
At what level of generality do you define a function? If there's a function, it seems like that's the debate in this case, is how general or specific is a function, right? Because if a function is fraud, then obviously that's not DART's function. But if a function is something broader than that, then maybe you are performing DART's function. So what do the cases tell us about how broadly or narrowly we define a function for purposes of deciding whether a contractor is performing it?
Well, see, now I might frame that differently because what I was just trying to impress you all on was that calling it fraud, that's irrelevant. Under 91A, it's the facts alleged, not this legal theory of liability. You can call it whatever legal thought.
There were misrepresentations alleged.
Sure, that's right. That is a fact alleged. So that's right. So what level of generality, I think, is answered by the statute, right, that gives DART its authority. And I think we've cited that. And I've got one quote here, just handy. DART is given a bunch of authority to run these public transportation systems. And what they can do is contract for the operation of all or a part of the public transportation system. The petition shows that DART is granting to MV Transportation the authority to contract for part of the public transportation system. So I think the statute giving DART its authority, which is pretty broad within this category of public transportation, is the answer to that question. How broad is the function? It's very broad if you're talking about public transportation in DART's service area. I want to pause and talk about why this result would be fair for a contractor like GDS. That they get zero damages for fraud when you're supposed to assume that, yes, we made these misrepresentations and defrauded them. Why is zero damages a fair result? And I've got three ideas for why that's a fair result. And one of them is this whole scheme of granting a limitation of liability, of damages liability to MV Transportation does not really change the legal landscape for a subcontractor like GDS. If DART was doing what MV Transportation was doing here, and DART could do it, DART could say, we're going to hire these operators directly. And if DART was doing that and committed fraud, then GDS would have no ability to recover damages from DART. Zero damages. And in this scheme, it's the same. MV Transportation is in between DART and the subcontractor. But GDS still gets zero damages for fraud.
Could the same thing be true if MV were accused of discriminating on the basis of race or discriminating on the basis of sex or something like that? Would the same result obtain here? Well,
Again, it depends on the facts alleged, right? Not the legal theory of liability. Could I imagine some facts that might be a DART function?
I mean, I can make some up now. I can make them as bad
Mhm.
ones.
Uh-oh.
I'm just trying to figure out the 452.056D, the extent to which you think the legislature has insulated MV as a contractor of DARTs against liability. So suppose that
that the allegations in the petition are that that MV would never hire a subcontractor if they were if they were run by a member of a particular race, or if they had people of a particular sex running the company like that. And if you need me to make them worse, I'll make them worse. What result under 452.056D?
Yeah, well, it does. Is it an intentional tort? I think you're describing what would be an intentional tort under the Tort Claims Act, right? There's no waiver for intentional torts.
So even though the DART, if it did, it could be sued under the employment discrimination statutes, you have no liability.
That's right.
Damn.
Why is that?
Well, I mean,
Liability is the extent of DART.
I'm sorry, you said
Liability is to the extent that DART would have liability, that would have liability.
so. That's considered an intentional tort. I mean, I think we're talking about, and
What
maybe
difference if DART has liability and your liability is measured by what DART's is, because there are other statutes that impose the obligation for the government not to discriminate on the basis of race. I don't see how the government is going to be liable, but MV gets to do it.
Okay, I see what you're saying there. Okay, yes. I mean, if DART has intentional tort liability for that, that's right. It does not apply to MV transportation.
Well, it's not intentional tort liability, it's liability under the employment discrimination statutes,
So,
which is a separate statutory scheme from the Tort Claims Act. So I think that's what we're asking you is, does it matter that they're separate schemes, or in your view, as long as DART's liable, even if it's under a statutory cause of action that's not a tort, is your view that because it's not the type of tort for which there would be a waiver, that you're still insulated from liability?
no. If DART has liability, right, all the statute says is our liability is equal to DART's liability. So I don't disagree with that. The question would be, is that an intentional tort that has been waived under the statute? And if the Tort Claims Act, which is state law, does not bar that claim, then we're in different territory.
Could I ask why MV didn't challenge the Court of Appeals holding at GDS to MV for the breach of the vehicle lease agreement?
Yeah, I think we determined that there was just a damages cap for that. We're just talking here about the tort claim. And so that would be, at least up to the damages cap, that claim would survive. The second thought I had about why it's not unfair to a subcontractor like GDS for it to have this result is because this statute, from the Transportation Code, it merely talks about a limitation of liability for damages. It does not take fraud out of the picture, for example, as an affirmative defense or as a basis for rescission and restitution. It's just a limitation on damages. And, the third thing, which I think is sort of obvious, is that if you're in this business dealing with government contracts, you know or should know that there are these liability limitations, there are these immunities, and that's part of the risk that you take, and you factor that risk into your business decisions. GDS pleads that it's been doing this for 23 years, so they would have known or should have known how this works. And this statute from the Transportation Code is not difficult to read. It's pretty plain language. It's not buried. This limitation is not buried in voluminous regulations somewhere.
Could I ask you about that on page 25 of your opening brief? Just because you use it twice, I'm just wondering kind of, you can show your work on this a little bit. Say that courts should strive to construe the statute the way a college-educated person would understand it, You say it should be assumed that a college-educated person working for MV Transportation or GDS would typically be charged with determining whether a proposed contract to provide public transportation is in the best.
All right. Did you hear and read that? Did you see that right there? That is ridiculous. Why are you saying that only a college educated person can understand these contracts? That to me seems so intentional to mislead, in my opinion. Not that my opinion is important, but I find that very, very disturbing. Here we go, disturbing language.
Interest in the business. What's your basis for saying that it ought to be a college-educated person? That's
Thank
the
you.
lens through which we ought to look at statutes rather than high school or law school or
Anybody.
Yeah, I'm pulling that out of the air, right? But it's like the reasonable person standard, right? Who is your reasonable?
Wait a minute. Let's see who reasonable people are.
Who would be dealing with public transportation at this level of complexity? Probably someone who is a college-educated person, or someone with sufficient experience, even though they have no college education, that they're equivalent to that. You could have the experience and the knowledge just from being in this business for 10 or 15 years.
Yeah, there are reasonable people who don't go to college.
Yeah.
Okay, hang on a minute. Now, under the statement he just made, hear me out. A reasonable person is a legal objective and a hypothetical standard used to determine negligence representing an ordinary person who exercises average care, caution, and judgment under similar circumstances. This fictitious individual acts sensibly balancing safety and risk to avoid liability. So that statement right there is an intentional attempt to mislead. Oh my God. I mean, it's an objective benchmark. See, it's just it helps courts and juries determine if a defendant's actions were negligent or if they acted appropriately. So it's much like saying not anybody that your average adult who did not go to college can't determine things accordingly. That is so inappropriate. But here we go.
Other questions? Sure. Thank you, Counsel.
I don't like that statement.
May it please the court, Ms. Pendry will present argument for the respondent. Thank you. Good morning. MDT was acting as a sales agent for its subsidiary MVC. Throughout the briefing in this case and in the trial court, MVT has said numerous times that it contracted with GDS. It did not. It was just making these multiple fraudulent misrepresentations and concealments on the basis of trying to sell a contract for GDS to give a really good price to MVC. Now, that was
you agree that DART has immunity from something as bad as fraud, right?
Well, yes, that fraud is not accepted in the Tort Claims Act. It's not allowed. So,
where exactly are you, just very concisely, how do you differentiate?
Well,
Because of what the statute says in terms of the liability being the same as the state's.
well, again, MVT doesn't get use of the immunity or the damageless limits or anything else if it wasn't performing a function of DART. And it wasn't performing a function of DART. MVC was. But in terms of its dealing with and what it did in dealing with my client, it wasn't performing a function of DART, it's performing a function of its ownership of the company that my client dealt with.
Because it wasn't the one that was contracting.
Correct. Excuse me. This sort of back, so I think your claim is a fraudulent inducement, right? And so if DART delegated contracting authority, whether or not it ultimately contracted with you or its subsidiary, is that the authority that we're looking at to determine whether that's delegated from DART, and if it is, whether it's covered by the immunity statute or the limitation statute?
Well, I still think delegation from DART was to MVT, but it wasn't to get contracts in, which then it gets in its own subsidiary to do the contracting. And I still don't think committing fraud is within that purview. But I actually want to explain a couple of things that would affect the public policy effects of your decision to adopt this sort of backdoor fraud, zero damages kind of thing. Because my client's been in the paratransit business many years, and he says this is a pretty unusual looking master agreement. And the implications are big here because it gave it gave MBT total control over the DART operations, total control. And so DART probably thought, oh, this is great. You know, we know we pay X dollars, and they do everything, including representing DART in a lawsuit and indemnifying DART. So as a taxpayer, I'm like, okay, that sounds good. Well, and of course, MBT was willing to do this because it was thinking it got complete immunity, it got all the protections DART would have, damage limits, whatever. Now, they probably learned the hard way in the Court of Appeals that Brown and Gay prevents that if you've got total control, no, you don't get that derivative immunity. So that was a bad thing to learn. But also, and which is why they're having the backdoor thing. But let's look at the fraud claims just a little bit. And again,
it sounds like you were describing a broad delegation of DART's authority to MBT, and doesn't that cut against you in that if the contract is broad, if the delegation is broad, then the scope of the functions that MBT is performing for DART is likewise broad?
That's a valid point, I think. But again, let's look at what happens here, because stretching it to this zero damages means no fraud kind of thing severely affects DART in the public. Not only did it say MBT gets to do anything, gets to do everything, it said DART can have no control, can have no access or discussion with GDS. Ditto, the GDS people, you can't talk to DART. The GDS people could not tell DART that all these misrepresentations were causing it to, number one, pay $120,000 out of its own pocket every month to try to keep the paratransit service operating, and that it was about to go into bankruptcy.
See, there's the real issue right here. So they're coming out of their pocket because of misrepresentation. They're coming out of their pocket to $120,000 a month to keep this transportation contract in place. But what ended up happening was the company that they contracted with, that GDS anyway, ended up in bankruptcy because they could not continue to subsidize this this company under the terms that the contract was, whenever that this master software that they invented, because they had to use their software to make this work. So once the software started failing, then the whole situation started failing. And then, you know, DART's over here, which is the transportation authority, they're over there, well, it's not in my hands, it's on your hands, right? Because they have this immunity situation. So we'll let her keep talking. I'm just trying to explain what's kind of going on here.
And I do want to just mention, again, you're at 91A, you're looking only at the allegations in the pleading. So, yeah, you don't have to look at the master agreement when we have very detailed allegations in the master agreement.
Question about that, so to interrupt there about this question of what is on the table in the Rule 91A context. So the pleading that we were pointed to is section 4, and in particular the factual allegations at paragraph 3 and 4. They say DART awarded a paratransit, microtransit, bus service agreement to transport. And at the end of that, it goes on to say a few other things. But what I want to ask you about is the citation at the end of that paragraph to the master agreement. It says, see the master agreement at page 25 of 137. So my question for you is, does that, first of all, is the master agreement a matter of public record? And does that citation get the entirety of the master agreement on the table for purposes of Rule 91A?
I think it gets the provisions we discussed from the master agreement. I will tell you, I think the reason it's not on the record is when the clerk was compiling the record, they're making you file exhibits separately sometimes, and the clerk put the thing in without the exhibit. Frankly, I think that's.
Oh, it was actually, it says it's Exhibit A. It was Exhibit A. It wasn't just forgotten in the actual original petition.
Uh-oh.
Right, it was there. Yeah. So. But again, it is the portions we stated. But I want you to know what we were saying, just in general, because this is where the.
I'm sorry. Is the master agreement a matter of public record?
Yes, it would be.
Oh, wait a minute. She goes, wait. Yes, it would be. That's not what she asked. She said, is it? That's what she asked. We'll keep going.
If a pleading refers to a legal instrument like a contract, and there's no dispute between the parties about what that contract is or the genuineness of it, should a court be able to take a look at the contract or the other legal instrument that the parties agree is genuine? And why wouldn't the court just look at that and make a decision?
Okay, because this is a 91A motion. The court can
So I understand that the argument that under the way 91A is written, maybe you shouldn't look at that. But why would that ever be a good idea for the court not to look at a legal instrument that the parties agree applies and is genuine?
Because again, the court can only look at the pleadings and see if
I understand that's your view of the rule, and so I'm going to step back from your view of what the rule means and just ask why would that be a good rule? Why would we want a rule like that? What is there to be said in favor of a rule that prohibits a court from taking a look at a contract that the parties agree binds them and may dictate the outcome of the case as a legal matter? But why would we not want a court to look at that?
Because there are other remedies. There are motions for summary judgment. There are other ways to get into looking at the contract. 91A
but they're more expensive and more time consuming. And if the parties agree it's right here in front of us, why on earth would we not want a judge to be able to take a look at that and perhaps end the case there?
Well, because that's up to the rulemaking, and the rule says you're totally looking at what did we allege.
What does it say in Federal Rule of Civil Procedure 12b-6? Because my understanding of the federal practice, if you went down the street to the Western District of Texas and you filed a securities fraud claim and you said there was something in the prospectus and it was fraudulent. If you've made reference to whatever was said by the issuer in the prospectus, then under Rule 12b-6, you wouldn't be limited to the four corners of the complaint, but rather the eight corners of the complaint plus the document referenced therein. Why should we read Texas Rule of Civil Procedure 91A differently than the Federal Rule of Civil Procedure after which it was patterned?
Because the wording of the rule is different, the cases interpreting the rule are different.
Well, we're the ones that interpret it. So I'm hoping that you can tell me a little bit more about what wording is different and why it makes a difference.
I can't look at them differently right now, but I have quoted your opinions that say this is the way we look at 91A.
Let me ask you about our rule, 91A, which says that a court consider solely on the pleading together with any pleading exhibits permitted by Rule 59. Pleading exhibits permitted by Rule 59. Rule 59 in turn says notes, accounts, bonds, mortgages, all other written instruments, and here's the key, in whole or in part, the claim sued upon may be, quote, made a part of the pleadings. So really, I think my question boils down to, by citing the master agreement with a particular pinpoint, a particular paragraph, have we made that part of the pleadings that may be considered under Rule 91A and 59?
That's possible. Yeah, I think that's a reasonable interpretation. But again, go back to, well, I need to use this.
The other aspect of this is I'm not hearing disagreement in terms of what the master agreement said, or at least that's not the focus of this dispute. You are seeming to agree that it also delegated this contracting authority.
It did. I agree with that.
Okay.
But they weren't doing contracting other than fraudulently concealing to sell to a different entity. We aren't who they contracted with. But let me get past that and kind of tell you this is what tees up. Because, again, now the fraud allegations were things like saying, we have this new payment method where you don't get your people paid by the hour, they get paid by the trip. And we promise 165,000 trips a year based on 9 years of doing this business for DART, which of course it was less than half of that, plus they didn't talk about cancellations or tell us anything. And it was representing this great new route match software would also be more efficient, and various other things. But then again, since DART could have no contact with us, let's think about what this does. If you approve this way of getting into full protection by the statutes that DART would have, your public transit authority is giving all the control to somebody, and it has no idea that it's committing fraud or any other thing it might be committing. It has none, yet it's.
She is making a great point right there, because they are not allowing this other company to get in the middle of any of this, and they are representing DART as being the ultimate person that the contract's with, but technically it's not really with DART. It's only really between these other two people, and I can clearly see fraud has happened here. So we'll keep going.
Giving all of its protections, which are meant to protect the public fisc, and in general protect the public, I think, especially when we're talking about paratransit, for example. So,
what does any of that have to do with what the statute means?
It has to do with this strange backdoor.
And it might be a crazy way to do it. It might be contrary to the public interest. I'm not convinced that the whole thing is in the public interest. That's what the statute says. The transit authority has the ability, and you allege it, whether we have the agreement or not, give full control to MV. Full control includes all of the things that you're describing. And if that's the case, maybe it's really a terrible deal for the people of Dallas. Maybe it's a great deal for the people of Dallas. That really is not something that we could possibly look to when trying to figure out what the words of the statute mean, can we?
You can, when you're considering the fact that Brown and Gay already said that because we have total control, we don't get derivative. Because it has total control, it doesn't get any derivative immunity. Nettles has already said that you don't get derivative immunity for fraud. You've already decided that. But this is coming in and saying, oh, well, maybe since if somebody sued DART for fraud, which they can't do, and there was a jury question submitted for damages, the only judgment that could be entered would be zero damages, because, again, this is up to all the lawyers to put this all in there. You can't really sue for fraud. which actually doesn't address the fact that you could ask for non-monetary damages for fraud, an injunction, for example. So we haven't even talked about non-monetary damages.
What do non-monetary damages have to do with this issue right now? You're seeking damages.
I'm just saying, right, I'm just saying, when you're looking at their argument and whether it makes sense to buy into that argument.
So that the argument would be, I take it, that if DART would be subject to non-monetary damages, then they are too. If DART is not subject to monetary damages, then they are not. You're seeking monetary damages, so under this statute, you can't get them, even if it's unfair. And I think I agree with you. I think it is unfair in this at least micro sense. There might be a larger sense in which just the desire to make sure that the government doesn't have subjection to their damages, maybe that's better. It's unfair to your client, no question, because we're assuming that fraud happened and you have to eat it if the statute means what they say. So does the statute mean what they say or not? It seems like it does. I'm not hearing any argument going straight to public policy, and I want to know why the statute actually doesn't say that an entity that you've alleged has total control over a public function, nonetheless isn't exercising that public function. I mean, that's all the case boils down to, isn't it?
But still, it's their back channel way of trying.
It's a statute. It's not a back channel way. I mean, yes, maybe they don't have derivative immunity, but there's this other statute. Maybe the other statute isn't there because you wouldn't get derivative immunity in that sense. So it's not about backdoor back channel. It's a statute. What does the statute mean?
Well, the statute actually means $0 in damages. Well, no, the statute.
Yes, it does.
It doesn't really go there.
It does mean that.
About things you could sue DART for, which no, fraud wouldn't be. But I'm also saying that MVT's argument doesn't even argue that it couldn't be liable at all because it couldn't be sued for fraud because DART Canton damages would be $0. It's not even taking into account that there could be non-monetary.
Are you seeking non-monetary damages?
We are not in this case.
And why wouldn't the case be dismissed? But if the statute, in response to Justice Young's question and Justice Lerman's question, is no, GDS couldn't sue DART for fraud, could get $0, maybe non-monetary, maybe not, and you want monetary damages from MVT, and you couldn't get those from GDS, then why shouldn't the Rule 91A motion be granted?
Well, again, because I don't think that backdoor way of trying to go into the result would be $0 damages. But also that interpretation really puts all public entities in a position where they're going to be subject to, I'm sorry, bad publicity, but also, damaging, for example, the paratransit riders' position about DART, which I've been involved in the whole Plano withdrawal system thing, and know a lot of those paratransit riders. But again, it would be opening up an approval of this total control thing that allows, even with law cases saying, no, you can't get immunity for fraud. No, you can't get immunity for total control. But yeah, you can do this. Oh, but DART would have $0 damages, which is essentially, I get the same immunity as DART, damage limits, whatever. But again, you have total control, and we can't even tell DART all the things you lied about and all the things you kept from us. I see my time is about up. I just ask the court to affirm the Court of Appeals in its entirety and send the case back to the trial court where we have the case against MP contract abated and we still have the vehicle lease and those other contract things against.
Any further questions? Thank you.
Wow. Okay.
Mr. Obenos, you have 5 minutes.
Thank you. I'm just going to make a comment about Rule 59 unless
A little rebuttal right there from him. So let's keep going.
there's some other questions, but I think I don't know the extent to which the contract is available to the public the way that maybe an SEC filing might be. If it is, I think Rule 59 could be interpreted to allow the courts to look at the public record.
It sounds like there's no dispute that it was actually attached to the petition at the time it was filed, right?
Yeah, I don't know. I mean, I never saw it. What we attached
What? You never saw it?
to our motion to dismiss. And for example, the main part of it, the statement of work, it's like a 24-page description of what this contract is about. And it's just, this is what we wanted, that we thought was relevant in terms of what is the function going on here.
Well, so their argument on that is that this is not a function of the authority because MV Transportation was not contracting. It was just making representations on behalf of its subsidiary that was contracting. What's your response to that?
That if DART was contracting out to these subcontractors directly, it would be making representations, which it was in this case. It was making, according to the petition, representations right along with us to enter into the subcontract. So how can you contract? You've got authority to contract. How can you exercise that authority without soliciting a contract?
Well, here it was two different companies, right? And so that's the question. Does that make a difference?
Well, no, it would not. I mean, I could commit fraud by inducing you into a contract with someone else, so just in terms of fraud. But, I mean, the statute authorizes DART to engage someone like MV Transportation to go out and plan and manage this service and to subcontract the operations. And in fact, I think that statement of work tells MV Transportation, you're not going to actually operate these buses. You're going to find operators and you're going to subcontract that out. So that's a direction in the statement of work. Do it this way. You're not going to run the buses. You're going to subcontract that out. So again, it comes back to, it seems like to me, if you've got authority to engage in these contracts, how do you exercise that authority without making an offer to contract, without communicating? You can't just leave your contract on the sidewalk and hope someone sees it.
Your friend on the other side mentioned a number of times that you barred DES from being able to even talk to DART, tell DART about how it's being harmed, all this kind of stuff. I thought there were some allegations, at least, that at some point, maybe this was before all the bad times came, that DART, MV, those were all talking together. Do you agree the idea that they were legally barred from talking to the government?
I don't know that they were legally barred. I think that statement of work, and in conjunction with the subcontract, the subcontract incorporates the master agreement, but arranged for complaints about the system to go to MV Transportation, because DART wanted MV Transportation to just run the whole show for this paratransit, microtransit deal. So
if GDS had sent a letter to DART that said, look, we're running our complaints through MV and we think you're throwing them in the circular file, but you need to know this, would they have been in breach of contract?
I don't know that they would have. I'm not saying that they would not have been, but I don't know that that's a breach. They probably would have a right to do that.
It's a serious constitutional problem to deprive someone of the ability to petition, right?
Right. So I don't know, even if that's in the contract, I think the answer to the question, and I don't know that it is, and I don't think it is, but I think it was just like when you run a business. If you got a complaint, go to HR. So it was that sort of direction rather than a prohibition.
Any further questions? Thank you, Mr. Upwells. Thank you to all counsel. The case is submitted, and the court will take a brief recess.
All rise.
Okay, the court is going to take a brief recess. Maybe when they come back, we will have better sound. I'm going to turn this down because it's probably screaming at you right now. I'm hoping they have got the sound fixed for on the next hearing because we know that this is already taking place this morning and we're finally getting to listen to it. That is why it was late today because they knew they had issues with the court streaming system, etc. So we are listening to it after the fact. Now their court recess will be fairly quick. So if you get a chance to get a drink of water, whatever, in the next few minutes, I'm going to go out of the feed from the court and come back into the feed to see if it's straightened up any of the sound issues that may have had from the first hearing to the second hearing, because there's actually 3 hearings today. So I'm going to take that off from there, and I'm going to go out and try to fix this and see if we can't fix our live streaming issue that we have with YouTube today and this particular hearing. So I'll give you just a minute. Let's go back out, try to pull it back up, and go to number 2, the second hearing of the day. So there was that. Let's go to Texas Live. Let's go back over here. Supreme Court Live. Okay. Oh boy. Let's go back over here and go to them and see if we can't find it. Okay. Bear with me just a second because we need to get back to the oral arguments that are happening today. It says upcoming, but this never came on, which is why we ended up over here. And this one. Okay, they're on break. And let's see if it's going to work now. Bear with me. I'm so sorry, guys. All right, let me add my live stream back. Share my screen. All right. We'll see if it's going to work now. After they get back from their break, they are on their current break. Pretty interesting stuff, isn't it? I mean, it seems to me, okay, they're coming back from their break. It seems to me like there's been some fraud that happened and there's a liability issue and it could have been avoided. Okay, we're going on to case number 2, I believe. That's not better.
All persons having business before the Supreme Court of Texas are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, the Honorable Court. Please be seated. Good morning. Welcome to the Supreme Court of Texas. We'll be arguing in 3 cases this morning. The first is case number 240924, NB Transportation versus.
Okay, we heard that one. Let's go on to the second one.
Basis of sex or something like
that. Let's go 5 minutes.
Okay. Well, we have to go back out and see if they have the second set of it recorded differently. So just give me a second. Let me see. That was the first part right there. Is this the second part right here? No. Let's see. Okay. Well, this sucks. I hope the other one is still available. I hope it's not gone, from today. So this was 3 hours ago. We just heard that one. Let me see. Come on. Yeah. All right. Let me see if I can find the next part of it from today. I don't know. I don't see the second hearing that they had today. I don't see the live stream for that one yet, which doesn't mean anything, but okay. Let me go see. I'm sorry, guys. They had problems with their feed today, and so now we're having an issue with our feed of trying to show you the Supreme Court hearings from today. Yeah. All right. So it looks like we might not be able to hear the second hearing of the day. Let me see if I can find it someplace. Supreme Court, Texas. Here we go. Just bear with me for a second. I don't want to miss it, but we already heard the first hearing of the day. Now we're trying to hear the second hearing of the day. But I'm not seeing it. I'm not seeing the live feed from that today. I only saw the first live feed. So we might not be able to hear any more today. We might be out. There's the one for tomorrow. Maybe they'll have their live feed fixed for tomorrow, but yeah. This is for today. As you can see, it's clearly not working. Okay. Well, that's the end of our live stream of the Supreme Court of Texas today because the other two hearings are not loaded up yet. That's because they had all these problems. So we'll just come back into it tomorrow and we'll replay the rest of the other two live streams from today and then jump on for tomorrow's live streams as well. There's two cases tomorrow as well. You know, I always appreciate you guys coming in and listening with me and thinking about these things and how the appeals court works and what it means to us as United States citizens and to us that live in Texas as our state, the great state of Texas. So I'm going to let y'all go for the rest of the day. Have a wonderful afternoon. Thank you for coming in. We always appreciate seeing you. Go out there and hug your babies. Life is short, and you know it's even shorter your time with them. You know, being an empty nester is the hardest thing I've ever done. I will say that. I'll see you later, guys. Bye. Thank you so much. Oh, and hit that like button if you get a chance.